Moving forward, the Supreme Court on Thursday fixed June 13 to hear a suit filed by the federal government against the 36 state governors over alleged misconduct in the handling of local government affairs. Justice Garba Lawal fixed the date while ruling in an application for abridgment of time argued by Lateef Wabemi to allow time for all parties to file their processes and exchange the same. He ordered the 36 state governors of the Federation to file their respective defenses to a suit instituted against them by the federal government seeking full autonomy for the 774 local governments in the country. Let me start with you, Mr. Ugochukwu. What is your take on this?
You know, as much as I'll give my own take, I'll be keenly waiting to hear the take of the legal lawyer here. Because to me, I've been very big on, you know, decentralization of power, impactful restructuring of the country. I've been very big on that, and that's why I had very high hopes. First, I had the high hopes in the confab of 2014, which I heard that one of the things they've implemented from that confab is returning us back to Nigeria with AOD. You know, it's a good thing. Then, I also had high hopes during the constitutional amendment processes, and to my great disappointment, I was living in a state that was among the 7 states that voted against autonomy, local government financial autonomy, and the only state in South to do that, which is Rivers State. Rivers State House of Assembly voted against local government autonomy. But then, whatever is happening there, at the Supreme Court, I think generally, holistically, it will be to the greater good of Nigerians. Yes, as a politician, we have political interest. If I'm a governor today, I would wish that I can exert more influence. But the moment I leave that office, I would wish that the other arms and part of government has some kind of independence, you know, because politics is mostly about interest. You know, the immediate past governor of Rivers State wield some kind of influence against local governments, you know, but as at today, you know, he would desire that local government chairmen should have some kind of autonomy. So the same way too, current governors now would wish that they should still hold on to their influence, but in next 4 or 8 years, when they eventually leave power, some of these laws, if it comes to pass, would be to their own advantage. You know, because no matter what, I've always clamored for a weaker public or weaker governors, weaker presidents, you know, to ensure that the people...
And stronger institutions.
Yeah, stronger institutions. I've always clamored for that. Politicians will always be politicians, will always have our political interest. But it's left for the people, you know, and other persons to ensure that they put that pressure and seek the balance. What I'm also saying, which I know cannot happen, that this should not be, as some persons suspect, that there are some kind of instigations from those that seek personal interest. But you cannot do that with 36 state governors, because it has to somehow conform with the general understanding. But let's wait and see what the Supreme Court will say. And I'm also keen to hear what, from the perspective of the law, from the point of law.
Ugochukwu is very keen to, to hear what you have to say, Ndamzi. All right, let's hear it. What do you have to say to this?
Yes, the Supreme Court is hearing that matter as a court of first instance, because the Supreme Court ordinarily, according to the Constitution, have the jurisdiction to hear matters affecting the federal government, the states, and the local government. So he pointed out about governors being so powerful and not wanting the local government system run very well. That is a fact. You see, the 1999 Constitution that was handed over to the civilian regime was a work in progress. It wasn't a finished document. Even the army, if you revert back to the document that was handed over, it was stated there. The document is a work in progress, but our National Assembly members saddled with the responsibility of remaking and fine-tuning this constitution. They have been busy with their constituency projects, busy with buying luxury cars, wardrobe fee, frivolous allowances, severance packages, traveling all over the world. They have abdicated completely their role of giving us good laws that will affect the life of the ordinary Nigerian. Now, Section 7 of the Constitution, like I pointed earlier, gave the legislative powers about local government administration system in Nigeria to the houses of assembly of the states. And it went further to create a state joint account. Okay? I remember in 1999, Obasanjo instructed the governors. It was an arrangement. Then the local government, they were receiving finances directly. If you dig back to 1999, the local government had autonomy, even though it was a constitutional provision that there should be state joint account with the local government. Then possibly it was an oversight. The local government, do your research, the local government were receiving funds directly until Mr. President saw, possibly from his advisors, saw that provision and insisted. And in my opinion, I think he acted on goodwill. Because the reason he insisted on having that joint account with states and local government was basically because the Constitution said not just owning a joint account and bringing out the money for the local government. The Constitution went ahead to say that the states will contribute more 10% in addition to what the federal government brings. The states will add 10% from the internally generated revenue. But I and you know what and how powerful the governors in Nigeria are. They seized that opportunity, you know, wherein the Constitution allows the states to make laws concerning the local government. They seized it. They turned the local government system to a settlement package for their boys. That's structure. So it is a constitutional crisis that needs to be healed. Yes, Oyo, let's look at Oyo instance. In the case of Oyo, the Supreme Court held that they should allow financial autonomy, and also the Supreme Court frowned at formation of caretaker committees. Supreme Court declared it unlawful and null and void. But there is a conflict of interest. Section 7 of the Constitution, where the houses of assembly derives powers to legislate on local government administration, allows them generally to make laws concerning local government. Now, if you look at the Rivers State Local Government Law number 5 of 2018, in our own law, it allows the House of Assembly, it allowed the governor to appoint, although discretionally, to appoint a caretaker committee at the expiration of the tenure of the local government. That is, if the State Independent Electoral Commission have not issued notices for election. Okay. Now, the Supreme Court have held otherwise. Supreme Court said no. Caretaker committees are unlawful. Stop it. But do you know why the governors cannot stop it? The states
Yeah,
have
empowered by
powers
the law, yeah.
to legislate on local government. So at this point, it is a question of the law. The National Assembly need to alter that section. Yes, I think a few days ago I watched the senators. They are beginning to talk deeply on Section 7 of our Constitution. I said, wow, which means people somewhere are listening. See, we cannot get it right with the local government administration in Nigeria if that section is not reviewed. That section needs to be reviewed properly, taking away the functions of legislation about local government from the houses of assembly.
And place where?
And it should be basically, the local government administration should be allowed. Why do we have the councillors there? The laws they make at the local level are not even effective. Their finances, the House of Assembly decides it. Who signs out the money? The governor. Now the question is, the states have been raping the Constitution since 1999. They have not contributed their own 10% to the local government account. Instead, they have underpaid the local governments. So the states have not been unfair to the local people. The states have not been unfair to the local people. So National Assembly need to step in at this time, heal that section of the Constitution clearly, allow the local government to draw their funds directly, disband completely the idea of caretaker committees, because it is unlawful, as the Supreme Court, which is the highest court of the, in the land, have pronounced it. And it is right that when a position is not inherent clearly in our Constitution, the courts make law at that point.
All right. Let me ask you quickly. I am concerned about, or I am curious as to how this will fly, because, I mean, Nigeria operates by a constitution, right?
Yes.
Now, the constitution says that with respect to this autonomy bill, this is not the first time, actually, that this bill is being brought up. You would recall that sometime last year, I think January last year, the National Assembly also brought up a bill for local government autonomy. But the Constitution says that it has to be ratified by at least 2/3 of the state's houses of assembly. And in this case, 2/3 is 24 houses of assembly. You would recall that some states rejected the bill.
Yes.
And that was the second attempt. I think the first attempt was just it was just one state. 23 states ratified it. They just needed one state to make it 24 so that it can be passed into law. And this has been what has handicapped the National Assembly from succeeding in passing this bill into law. Now, from the actions of the Attorney General, is he setting aside the Constitution to go to the Supreme Court to enforce this? Is it legal?
Yes. Let me answer this question beginning from the first leg of the question, where you said that particular position needed ratification from states. Yes. But look at Section 4 of the 1999 Constitution. It talks about the National Assembly. There shall be a National Assembly with the powers to make laws. See, lawmaking is a process. The law have given them, the senators and the reps, powers to make laws for the good governance of Nigeria. Okay? They have the powers to alter that section that allows ratification from houses of assembly. If today a member of the House or a senator of the Republic sponsors a bill altering that section that allows ratification, it will stand. That is the reason Section 4 allows them, National Assembly, to make laws for the land. So, the Attorney General the Attorney General acted in good faith, considering there are crises almost in all the states of the Federation about local government. Some states entirely have never conducted local government election. Some have been operating with caretaker committees for over 6 years.
In fact, it has it on record that about 313
local governments
out of 774
local
governments are being run by sole administrators, not even caretaker chairmen.
So you see that the state governors in this regard have raped our constitution severally as regarding the local government administration in Nigeria. And in my own opinion too, lack of proper administration, efficiency in the various local governments in Nigeria have also contributed to why we have this insecurity all over Nigeria. Because the idea of the local government administration system is to bring government closer to the people. But in this case, the government that is supposed to be nearer to the local farmer, that is nearer to the artisans in the street, is now far. It has become a strategy of settling those who they perceive as political loyalists. So we should look at this thing critically as affected by Nigeria. We are all affected. We are Nigerians, firstly, before we became political party members. So if our local government system is not running well, the development we seek in the local level cannot come. Have we bothered to ask the state governors how much they have contributed with their 10%? They have not.
But then, you're yet to answer the question when I asked about the Attorney General of the Federation, if he is setting aside the Constitution to go with the Supreme Court to enforce this law that the State's House of Assemblies have refused to ratify. Now, when you look at it on the flip side, this is on the side of the Attorney General of the Federation and the Supreme Court now enforcing what has not been ratified and passed into law. That's on one hand. Then the other hand, on the flip side, is the National Assembly. Why can't, since this is the lacuna that the State Houses of Assembly has, taken advantage of to make this bill not be passed into law, can't the National Assembly now amend that section of the law, removing, the powers to ratify such bills from the State Houses of Assembly?
Okay. Firstly, the Attorney General of the Federation is the chief law officer of the country. And in my opinion, I think he is directly affected here. There are a series of complaints, petitions from various local governments in Nigeria. And it has become a national concern. It has become a national concern that we have a uniform system of administration of local government in Nigeria. So I don't think the AG applied to the Supreme Court to basically alter the Constitution. No. The reason is this. He has found out that the lacuna there is just so much that one cannot overlook anymore. And there is this thing in law that when a law is not straight, when it is vague, or a particular law does not intend to bring good governance, at that point the court can hold otherwise.
Okay.
And in my opinion, that is the reason I think the Supreme Court declared the idea of caretaker committees null and void. Okay. So it is a question of constitutional amendment. And I am happy that the senators this time are beginning to listen. They have begun talking about Section 7 as moved by Senator Kao in the House.
All right. Mr. Gochukwu, finally, your final statement.
Yes, you see, this whole assembly thing is quite interesting. And I've been thinking, you know, could there be any disadvantage of having, because these are 774 micro self-federating units, and having them stand alone. We already see what states, 30 states and their head of government can do. And then you now have 774 micro persons on their own all over the place. Because if you're removing, the intention of having that Section 7 per se, like you pointed out, is to have some kind of overseeing, this, around. If you take that away, where do you place it? You take it back to the National Assembly, or do you now place it in their own hands? So if you now make the chairman to have their own legislative, this thing that makes their own laws and control them, what is the binding force? Because it's easy. Now you can say it's just the governors that, in quote, are abusing them, but they still have some kind of bound around them. Then when you leave them individually, you now have possibility of 774 persons abusing 774 micro federating units in the country.
No, that wouldn't be the case, because they have their own legislative chamber which happens to be the various councillors from different wards in a particular local government.
So you can now have 774 persons with different, diverse kind of laws and approach to.
No, it is even now that the local government, now that the local government does not have autonomy.
Right.
We have councillors which happens to be the legislative arm of local government. Yes.
So
but they have some kind of some kind of uniformity, in quotes. Well, now you can now have a local government that will choose to say they have this unique law for themselves, and then you go to Ahuda East, for example, we have these unique laws for themselves, unchecked.
No, we will not use the word unchecked, because the laws are made for the local people. And the idea of local government administration is all about development. And you can see, because of shortage of funds, deductions, and all that, they are not performing.
All right.